Welcome everyone. Today's topic is decree and we are dealing with the subject the Code of Civil Procedure. Decree is defined under section 2 clause 2 of the Civil Procedure Code. It is a formal expression which determines the interest of both the parties in a conclusive manner with regards to any disputed matter in a civil suit. Significantly, a decree is a formal expression of adjudication by which the court determines the rights of the parties regarding the matter in a controversy or a dispute. A set-off or a counterclaim can be obtained on a decree. A decree shall be deemed to include rejection of a plaint, determination of any question under Section 144 of the Act. A decree might not include any adjudication from which an appeal lies as an appeal from an order, any order of dismissal for default. Now, understanding what are the essential elements of a decree. Number 1, there must be an adjudication. To constitute a decision of the court to be a decree, there must be an adjudication, that is, a judicial determination of the matter in dispute. If there is no adjudication, judicial determination of any matter in dispute, it is not a decree. Thus, a decision on the matter of an administrative nature is not considered as a decree, inasmuch as it does not judicially deal with the matter in dispute. Further, such judicial determination must be made by a court. Thus, an order passed by an officer who is not a court is not a decree. Second, the adjudication should be done in a suit. What do you mean by the suit? Now, the court does not define the word suit, but ordinarily it means, and apart from some context, must be taken to mean a civil proceeding instituted by the presentation of the plaint. Thus, every suit is instituted by the presentation of the plaint. It means that if there is no civil suit, there is no decree. Thus, rejection of an application for leave to sue as forma pauperis is not a decree, as there is no plaint till application is granted. Coming to the third point, that is, it must determine the rights of the parties regarding the matter in dispute. The adjudication must have determined the rights of the parties with regard to all or any of the matter in controversy in the suit. The word rights means substantive rights of the parties and not merely procedural rights. Thus, rights of the parties inter se relating to status, limitation, jurisdiction, frame of suit, accounts, etc. are rights of the parties under this section. The rights in matter of procedure is not included in it. Next, coming to the fourth point, the determination of the right should be of conclusive nature. Such determination must be of conclusive nature. In other words, the determination must be final and conclusive as regards the court which passes it. Thus, an interlocutory order which does not decide the rights of the parties finally is not a decree. For example, an order refusing an adjournment or an order striking out defense of a tenant under the relevant act or an order passed by the appellate court deciding some issues and limiting other issues to the trial court for its determination are not decrees because they do not decide the rights of the parties conclusively. On the other hand, an order may determine conclusively the rights of the parties, although it may not dispose of the suit. Thus, an order dismissing an appeal summarily under Order 41 of the Code or holding it to be non-maintainable or a decision dismissing a suit for want of evidence or proof are decrees, inasmuch as they decide conclusively the rights of the parties in the suit. The crucial point which requires to be decided in such a case is whether the decision is final and conclusive, is essence and substance. If it is a decree. If it is not a decree. Now coming to the next point, the determination of a right should be, there must be a formal expression of such adjudication. The formal expression must be deliberate and given in the manner provided by law. The decree follows the judgment and must be drawn up separately. Thus, if a decree is not formally drawn up in terms of the judgment, no appeal lies from the judgment. But a decree need not be in a particular form. Thus, a misdescription of a decision as an order which amounts to a decree does not make it less than a decree. Next, coming to the types of decree. In a civil procedure code, there are three kinds of decrees which are recognized. Number one, preliminary decree. Next is final decree, and the last is preliminary and partially final decree. What is a preliminary decree? A decree is identified as a preliminary decree when an adjudication decides the rights of parties regarding all or any of the matter in dispute, but it does not dispose of the suit completely. A preliminary decree can be passed by the court in the following suits as provided by the court, as in Order 20 Rule 2, suit for possession and mesne profit, Order 20 Rule 13, administration suit, Order 20 Rule 14, suit of preemption, etc. Coming next to the final decree. A final decree is recognized as final when it disposes the suit completely, so far as the court passing it is concerned. A final decree settles all the issues and controversies between the parties to the suit by the court of law. A decree may be said to be final in following ways. Number one, when no appeal was filed against the said decree within the prescribed time period. Number two, the disputed matter in the decree has been decided by the highest court. And lastly, when it completely disposes of the suit. In following ways, we can say the decree has become final. Lastly, coming to partly preliminary and partly final decree, a decree shall be held as partly preliminary and partly final when it determines certain disputes but leaves the rest upon the further decision. What is executable in a final decree and the one which is not executable is a preliminary decree unless it merges with the final one. What are the contents of a decree? Before knowing the same, we must know that the decree shall always agree with the judgment, since the decree follows the judgment. So the contents of the decree are provided under Rule 6 of Order 20, and following are the contents: the number of the suit, the names and description of the parties, the registered addresses and particulars of the claim, and shall specify clearly the relief granted or other determination of the suit. The decree shall also state the amount of cost incurred in the suit, and by whom and out of what property and in what proportions such costs are to be paid. And lastly, it must contain the date on which the judgment was pronounced, and the signature of the judge should also be there on the decree. Now, what is the time limit for drawing up of a decree? According to Rule 6A of Order 20 of the Code of Civil Procedure, the decree shall be drawn within 15 days of the judgment. An appeal can be favored or preferred without filing a copy of the decree if it is not drawn within 15 days of the judgment. Lastly, to conclude, we should understand what is the basic difference between judgment and a decree. A judgment is made prior to decree, while decree follows a judgment. A judgment is based upon facts, while a decree is based upon judgment. A judgment contains facts of the case, the issues involved, the evidence brought by the parties, finding on issues based on evidence and arguments, while a decree contains the outcome of the suit and conclusively determines the rights of the parties with regard to the issues in dispute in the suit. The definition of the word judgment, given in Section 2, Clause 9 of the CPC, does not include the word formal, while the definition of the word decree, given in Section 2, Clause 2 of the Code, includes the word formal before it. Judgment leads to the final disposal of the suit after the decree is drawn up, while after passing the decree, a suit stands disposed of since the rights of the parties are finally determined by the court. Hence, by this, we have clearly understood the distinction between decree and judgment. Thank you very much.